Lordship, may I please make a mention regarding item number 12, which is hearing matter.
Yes.
My Lord, as the leading counsel, Mr. Angsuman Bora could not appear today due to some personal difficulty. If the matter be taken up after 2 weeks,
As prayed for on behalf of Mr.
Angsuman Bora.
Anshuman
Bora.
Bora,
Yes, my Lord.
Senior
Senior
Counsel.
advocate, yes, my Lord.
Senior Counsel,
Yes, my Lord.
appearing for the appellants. This is the matter again after 2 weeks.
I'm obliged, my Lord.
For motion, item 1.
Just a minute. This was item 12. Okay, item 12.
For motion, item 1.
May I please, Your Lordship? I'm
Yes.
appearing on behalf of my senior Priscilla Tangmoya, counsel for the petitioner. He's on leave due to medical difficulties. So kindly fix
Please
the
repeat.
mat-
What did you say?
He's on leave due to personal difficulties.
He is on leave.
Yeah.
Is there any provision for taking leave? Who is he? Mr.
Priscilla Tangmoya.
Okay, out of station.
He-
He's out of station or is in station?
He's out of station, Your Lordship.
Mr. Please write down Mr. P.C. Lalthangboy, learned counsel for the petitioner, is said to be out of station. And on a prayer made on his behalf, matter stands adjourned for
Monday.
a week. Okay. This
For-
is an
For orders, item 6.
Yes.
My lord, this is bail application.
Mm.
Um,
Why has it come before this court?
my lord, the co-accused, Daniel Negi, was disposed by your lordship.
You have a copy of the order? How was it disposed?
Rejected. It
Was
was
rejected.
dismissed.
Lal Gil Nahi.
Yes, my lord.
You have a copy of the order?
Yes, we do have a copy, but we have not annexed in the bail application. And also, my lord, with regard to that, if I may make one correction with regard to our application, that we have mentioned in our application that one of the co-accused was already released on bail.
Where? You need some correction?
Yes, my lord, we had
Where? Which page?
page number 7, para number 8.
Page number 7 is paragraph 9, 10, 11.
My lord, page number 6, para 8.
Okay, 6. Page 8. Para 8.
The last paragraph of para 8.
Ah,
It is pertinent to mention that the co-accused of the instant applicant has been released on bail by the learned judge special court in the NPS Act.
so?
My lord, nobody is released yet.
Okay.
Because in the rejected bail application, which we have annexed in Annexure 6, page 156, it was stated that one of the co-accused has been released on bail and the accused petitioner is entitled to parity as he has been in judicial custody. It was stated like that. So we were under the impression that one of the
see.
accused.
This order is passed in the application filed by the present petitioner,
Yes, my lord.
the same petitioner,
Same petitioner
before the trial court.
before the trial court.
Okay. The statement was made that the co-accused has been released,
Yes, my
but
lord.
fact remains that not released.
Yes, my
okay.
lord. We made inquiry to the counsel in the trial court. However, orally they've told us that one of the co-accused was released and they are applying for the certified true copy of the same. However, we have no knowledge as of now.
So you have no information regarding release of the co-accused. How many accused persons are there, by the
My
way?
lord, 5.
5.
Yes, some of them are discharged.
Okay. Where's the FIR?
My lord, the charge sheet is at page 14, annexure number 3.
Page 40,
14.
14. Okay. Now, these are the accused persons, right?
Yes, my lord.
So present petitioner is number 2.
Yes, my lord.
Okay. And who has been discharged?
Accused number 3's husband and my lord Vung Khantona, the drive.
No, there are 5 persons named here.
Yes, my lord. Apart
are-
from that, there are another 2.
Where?
My lord, page 23. Zoram Chuan.
Page 23.
Yes, my lord. Report of seizure and arrest.
Yes.
At the bottom, number 2. Following this seizure and arrest, I requested SI Rinsanga to arrest the main participant in the case. So and so, my lord, number 1, Langil Nei, number 2, Zoram Chuana, number 3, Vung Khantona. And these 2 are released.
These 2 are also the accused persons.
Yes, they were discharged.
They have been discharged.
Yes, my lord.
So who all remains now then? The first page of the charge sheet,
Yes, my
there
lord.
are 5 names.
Yes, my lord.
So all of them are in custody.
That we are not very sure, my lord. If we may be given time to, like 2-3 days time to clarify again.
Now, you said that some person was supposed to be released, but he's not released. Who is that co-accused person? Who are those co-accused persons? Are they the ones appearing at page number 14?
Yes, my lord, we were thinking that those were the persons. The discharge, maybe they got confused with the released on bail, as released on bail.
Jahir Alam, Dalgil Nei, Amir Hussain, Sukanta Karmakar, and the instant petitioner. So all of them are the accused persons,
Yes, my lord.
and none of them have been given bail. And only Zoram Suana,
And Vung
he has
Khantona.
been, and Vung Khan, they have been discharged. You
Yes,
say.
my lord.
You have a copy of the discharge order?
No, my lord.
Anyway, what is the ground for seeking bail? How many times have you sought for bail
This is the first time, my lord.
in the
In
High
the
Court?
instant applicant by
In the High Court.
in the High Court, yes.
Trial court, you have already.
Yes, we have already.
Okay. So tell me, what is the ground for bail? Why are you seeking bail? And of course, now how many witnesses are there and what is the stage? That also you tell me.
There are 11 witnesses,
Uh-huh.
and now in the last court order, it's the stage is prosecution evidence. PW number 5 is summoned.
Fine. How many witnesses are there in all?
My lord, 11.
11.
Yes, my lord.
So how many remains to be examined now?
My lord, just as far as we know, just 2 of them are remaining.
Who are they?
Number 5, PW number 5, and PW number 5 and my lord, PW 11.
There's some marking against the numbers. Triple X.
Cross-examined.
They have been cross-examined or what? What does it mean?
This is written by the office. So my lord, that
So, Ms. Langai, Saki, tell me, what is the ground for seeking bail and how you were arrested? You are not prepared today. You seem to be nervous. I don't know.
yes, my lord, yes. I'm a little nervous because we have very urgent case which your lordship has already rejected before, and which I was reading 2 files at the same time, and so I got a little confused.
No, you have another case.
Yes, my lord, which your lordship had already told, not rejected exactly, we have withdrawn. Your lordship had advised us to go to the district court.
Which
And-
case? Which case? Is
No,
listed
we have
today?
not filed yet. We'll be filing, my lord.
Or you'll be filing it?
That's why it was very urgent, and the bailer was already arrested, and she was put in jail. However, they pleaded with the special judge of Lunglei district, and then I was reading 2 files at the same time, so I got a little confused. And my lord,
Okay, you prepare.
if it may be listed again
You
tomorrow.
prepare. Tomorrow it may be slightly difficult. You see,
Monday.
we'll get listed on some other day because, in fact, anyway, this matter has to be listed before this court, isn't it?
Not necessarily this one, but the one that we will be filing today, it has to be listed before your lordship.
And this also has to be listed before me. That's why it's listed today. It was
That is-
mentioned on 2 occasions. I got it listed today.
However, my lord, there is a notification saying that if your lordship is not holding a criminal court and if you're outside Aizawl bench, then it can be taken up by other.
Is it like that?
Yes, my lord, there is a notification.
Ms.
Yes,
Mary?
Your Lordship, subsequent to the notification wherein the all the cases that was disposed, it has to be dealt with by the same judge. But then now a new notification has come up, which my learned friend have just said.
Okay, if the judge is out of station,
Yes,
then any other judge can take it up.
yes,
But if the judge is in station, it has to be taken up by the same judge.
same.
My lord,
So-
it's notification 12, dated 12 February 2025.
Do you have that notification? Where is it? It's in the website?
Yes, my lord. My lord, I can submit it before the bench assistant later on.
Can we have it? Where's the notification? I have also to be informed about these things. Notification number 27,
Notification 12,
12. Dated?
dated 12 February 2025.
But that has been superseded by notification 27, dated 3rd May 25. All bail applications arising of the same FIR which are filed in the Guwahati High Court are to be listed before the same honorable judge who had previously disposed of the bail applications pertaining to the said FIR.
My lord, which year was that?
Notification number 27, dated 3rd May 2025.
Then, my lord, then that means it has to be listed before you.
In case of subsequent bail application preferred by the same accused, this also covers the case. So that is why it was, I've seen court has also,
Motion.
as per point number 2. Okay, you are right. This is the notification, 27th to 3rd May. It also says, however, in the event the Honorable Judge is sitting in a division bench or is not holding criminal roster or is stationed in a different state under the jurisdiction of the Guwahati High Court, the instant direction would not be applicable and such matters may be listed as per roster. Except in cases of subsequent bail applications as mentioned in point number 3. Now, what is point number 3? In case of subsequent bail application preferred by the same accused in the same FIR, bail has been rejected earlier. Bail application should only be listed before the same Honorable Judge. So this is the criteria. Same FIR, bails should be listed before the same judge, with the exception that if the judge is not sitting in division bench, is sitting in a division bench, not dealing with criminal bail applications, and is not holding a criminal roster or stationed in a different state, then it will not apply. But if the same applicant has been rejected earlier by the same judge, then it has to be, whether he is outstationed or wherever he is. So your case is not rejected by this court.
No, my lord.
It has been listed only for the fact that there was an FIR,
Yes,
common FIR.
Yes, my lord.
So you have that liberty to take it up to submit before other court also. It's up to you.
Yes, my lord. If it may be listed next week.
Next
then-
week, okay.
Yes, my lord.
As paid for by learned counsel. Miss Mary, what do you say?
No objection, Your Lordship.
How are you prepared with this bail application?
I have submitted the few
The records are here, isn't it?
Yes.
But just find out what is the status of the thing.
Your Lordship,
Trial.
the matter is will be listed again for on 17/11. Only PW number 5 remains, and someone is issued.
1711. Okay. Anyway, we'll have it next week. Make your submissions then. That's paid for by Ms. Lalnai Saki, Panai, learned counsel for the petitioner. List the matter again next week.
Obliged.
Item 7.
May please, Your Lordship.
Yes.
My Lordship,
This is also again tied up
my
with
lord.
this court, or it's not like that.
no, my Lord, this is the first time I have approached this Honorable Court.
Okay, first time.
My Lord, since TCR has been called and has been received, if I may be allowed to proceed with the hearing of the instant case.
Scan TCR.
Yes,
Well, where is it?
it has been received, my Lord. It has been called for
Oh.
at the last court date.
You have gone through it.
No, my Lord. It's
Then
not
you can-
required, but it's
Then
not
you go
required.
through it. You go through it and make your submissions on
Not,
Monday.
not required, my lord, because the only reason why the scanned copies of the TCR are relevant is because I have made my submission as to the grounds of arrest. They have not been furnished to me, and it is there in the charge sheet as well, and it will also be there in the TCR. So I don't think TCR, unless necessary, I don't think it requires to be gone through as of now. My lord, I have been arrested on 15/8/2025.
You bring the TCR here and keep it here. Miss Mary, you are ready?
Yes, Your Lordship.
All right. Arrested on
15/8/2025.
Yes.
for
then-
an, along with another co-accused for an alleged possession of 111 grams of heroin. I was accordingly booked under Section 21B of the Indian PS Act.
Yes.
Thereafter, my lord, charge sheet has been filed before the Honorable Trial Court, and
When?
I'm not sure as of the date, but I have received the same on 24/9/2025. The complaint sheet is dated 16/9/2025.
Page number?
The complaint sheet is in page number 21 to 58.
Charge sheet dated?
The charge sheet is dated 16/9/2025.
So how many
There
accused? Two accused persons.
Yes, my lord. Thereafter, I have filed my bail application. However, the same was rejected via order dated 15/10/2025.
Bail filed before the trial court.
Yes, my lord.
Okay. Then?
The same is in. I have annexed a copy of the same in page number 59 to 61. Hence, I have approached this honorable court, my lord. My lord,
What was your grounds for bail in the trial court?
the grounds for my bail application are almost entirely the same with here, with my bail application here, my lord. The grounds for my bail are: one, the rigors of Section 37 of the Indian PS Act, they have not been attracted with, and two, there is no conscious possession. And three, the grounds of arrest, they have not been furnished to me as laid down by the Honorable Supreme Court. Hence, there is non-compliance of Section 47 of the BNSS. And fourth, charge sheet have already been filed, so my detention is unnecessary. Now, firstly, my lord, if I may take you to the information report.
Now, how are you connected with this co-accused person?
She's my mother, my lord.
Mother?
Yes, my lord. If I may take you to the report of seizure and arrest.
Oh.
The same is in page number 23.
Yes.
If I may read, my lord.
Yes.
To the officer in charge, Anti-Narcotics Squad, Excise and Narcotics Department, Aizawl, subject report of seizure and arrest. Sir, I humbly bring to your notice that on 15/8/2025 at around 2 a.m., I received information from my source that Lal Chonphuang and her son Lal Mingliana kept heroin at the residence of Lal Chakimi of Ramplun Vengthar. Upon reaching the residence of Lal Chakimi, I recorded grounds of belief and conducted search in the presence of reliable civilian witnesses, and the two suspects. Lal Minglian stated that he kept his own heroin and that of his mother at Lal Chakimi's residence. He kept his mother's share at the same place according to her wishes and had already sold his share. As the possessor of the heroin is a female, I obtained permission for her arrest from JMFC. I seized the suspected heroin at 3:40 a.m. and also arrested both Lal Chonphuang and her son Lel Ming Lian, for possession of the same. I did not arrest the owner of the residence as she was unaware of the content of the articles they kept in her residence. Details of seizure and arrest is shown below. Now, my lord, as I have submitted earlier, since I have been charged under Section 21B of the NDNPS Act, the rigors of Section 37 does not apply. So that means we will have to factor in the two principles of bail jurisprudence. The first one,
No, why do you say 37 is not attracted?
37 is not attracted because 37 is attracted in commercial quantity cases. Section 37 says in commercial quantity cases,
How much was commercial quantity? Will
111 grams.
Huh?
111
No,
grams.
commercial quantity is how much?
Commercial quantity is 250 grams, my lord.
It has to be minimum 250.
Yes, my lord.
Okay.
According to the notification issued by the union.
So 37 is not attracted, then what happens?
So 37 is not attracted. As per Section 37, one, the public prosecutor has to be given an opportunity to object the bail application, and two, I have to reasonably show that I am somehow not guilty of the offense. I have to show those.
No, you don't have to show anything. The court has to believe.
Yes, my
has
lord.
to be satisfied
Yes, my lord. It has.
that there are reasonable grounds for believing that you are not guilty of the
Yes,
offense.
correct, my lord. So since those provisions, since the provision of Section 37 is not attracted, we will have to see the two principles of bail jurisprudence.
Yes, what is that?
The first is whether my incarceration in jail is necessary. And two, whether the principles laid down by the Supreme Court in P. Chidambaram's case, they are satisfied with. If I may take you to the relevant judgments, my lord.
How many witnesses are there in all? 6.
My lord, there are 6 witnesses, yes.
And how many have been examined so far?
None, my lord.
Huh?
None, my lord.
None have been examined. Okay, you arrested only 15-8. Okay.
The first citation, my lord, which I would like to provide is 2012 1 SCC 40. This is Sanjay Chandra's case. This is regarding bail jurisprudence. The relevant paras are para 21 to 23 and para 40.
Para 40.
40, my lord.
In
If
this
I-
case, what was, is it a case of NDNPS? It's not a case of NDNPS, isn't it?
Yes, my lord.
It's 2G spectrum scam,
Correct. But this is regarding the
anti-corruption.
yes, my lord. But this is regarding the general jurisprudence of bail. The Supreme Court have, although this is not a specifically an NDNPS, this case does not specifically arises from an NDNPS case. However, the principles of bail have been laid down here. If I may read from para 21, my lord. In bail applications, generally it has been laid down from the earliest times that the object of bail is to secure the appearance of the accused at his trial by reasonable amount of bail. The object of bail is neither punitive nor preventative. Deprivation of liberty must be considered a punishment unless it is required to ensure that an accused person will stand in his trial. I will go a bit downwards, my lord, from para 22. From the earliest times, it was appreciated that detention in custody pending completion of trial could be a cause of great hardship. From time to time, necessity demands that some unconvicted persons should be held in custody pending trial to secure their attendance at the trial, but in such cases, necessity is the operative test. This part is very important, my lord. Necessity is the operative test. Whether my incarceration, whether my detention in jail is necessary, that has to be shown by the prosecution. And unless my detention in jail is necessary, there is no reason why I should be incarcerated, my lord, pending trial.
You are a habitual
No, my lord.
Offender?
No, my lord. There is
Because
no previous case reference or anywhere upon me, my lord. Although the report has been written here as it is, if I may take you to my particulars, which is annexed in the
No,
charge
you,
sheet as
you
well.
finish this judgment first. You have also mentioned page 30, paragraph
Paragraph
40.
40, yes, my lord.
What is paragraph 40?
If I may read, my lord. Paragraph 40. The grant or refusal to grant bail lies within the discretion of the court. The grant or denial is regulated to a large extent by the facts and circumstances of each particular case, but at the same time, right to bail is not to be denied merely because of the sentiments of the community against the accused. This is very important, my lord. The primary purposes of bail in a criminal case are to relieve the accused of imprisonment, to relieve the state of the burden of keeping him pending the trial, and at the same time to keep the accused constructively in the custody of the court, whether before or after conviction, to assure that he will submit to the jurisdiction of the court and be in attendance thereon whenever his presence is required.
So you are a resident of?
I'm a resident of Am Veng South, my lord. And there is no reason why
What about the co-accused?
the co-accused,
He's also in jail?
yes, she's in jail, my lord.
Both of you?
Both of us, we are in jail presently.
Okay, then?
And the P. Chidambaram's case, my lord, 2020, 13 SEC 337, para 21 and 23.
Paragraph 20.
21 and 23. If I may read, my lord.
Read.
The jurisdiction to grant bail has to be exercised on the basis of the well-settled principles having regard to the facts and circumstances of each case. The following factors are to be taken into consideration while considering an application for bail: the nature of accusation and the severity of the punishment in the case of conviction, and the nature of the materials relied upon by the prosecution. Reasonable apprehension of tampering with the witnesses or apprehension of threat to the complainant or the witnesses, reasonable possibility of securing the presence of the accused at the time of trial or the likelihood of his abscondence, character, behavior, and standing of the accused and the circumstances which are peculiar to the accused, larger interests of the public or the state, and similar other considerations. And para 23 is an extract from Kalyan Chandra's judgment, my lord. They are more or less the same. And secondly, my lord, the actual owner of the house where the seized articles have been seized, she has not been arrested, and it has merely been stated that she did not know the contents of the seized articles. And that is why she has not been arrested. However, we, on the other hand, we do not even live there. We were arrested, and the proximity, my lord, we have to consider.
Where do you live? What were you doing there then?
They brought us, my lord,
Who brought you?
the excise personnel. They brought me to that place,
Okay.
and
Just a minute. Lal Hakimi. Lal
Yes, my
Hakimi, the house owner.
yes, my lord. She lives far away in Ramlunvengthar, my lord.
Okay, yes.
And I would like to briefly submit, my lord. Earlier, I have also filed another bail application before this honorable court, which was disposed by Justice Longkumar. Therein, I have also stated that Section 37 of the rigors of Section 37
Where,
has
where?
not been attracted in bail application 44 of 2025. I've submitted.
Have you
before.
annexed it?
I've submitted today, my lord,
Bail applications filed by whom?
by myself, my lord.
Same applicant.
No, my lord, I would like to take that on record because on that bail application 44 of 2025, um, um, the accused is different, my lord. What I would like to, why I'm saying that is because therein, I am also granted bail just because the rigors of Section 37 of the NDNPS Act has not been attracted.
Oh, bail was granted. in
Yes,
that
my
case.
lord.
Where is that? Where is the
I-
judgment?
I have submitted before the court today. Bail application 44 of 2025. I think it will be in the bottom. Herein,
No, this is a different applicant, isn't it?
yes, my lord, different applicant.
Not connected with this case.
Yes, my lord, correct. I'm just impressing that upon this honorable court to show that, my lord, even this coordinate bench have granted me bail just merely because the rigors of Section 37 has not been attracted.
PP was heard, charge sheet already filed,
Correct.
investigation completed,
Same
matters
circumstances.
awaiting trial, and then 21B,
Same circumstances, my lord.
intermediary quantity.
My lord. So if some sort of parity, some sort of view of parity may be hold here, my lord, if your lordship so permits.
What about your mother?
My mother, she has not applied for bail.
She did not apply.
Yes, my lord, even before the trial court, as of now. And another very interesting thing is that even though the grounds of arrest have been annexed there in the charge sheet, it is not as per the requirements laid down by the Supreme Court in Vihan Kumar and Prabir's case.
Where is that?
The grounds of arrest, my lord.
Yes.
The grounds of arrest,
Which?
page number 28. These grounds of arrest, the reason why the trial court also dismissed my bail application before the honorable trial court is that both of our signatures are there at the bottom. However, my humble submission is that these specific grounds of arrest, this has not been written down as per the requirement laid down by the Supreme Court, and it has not been given to me written. And my relatives have also not received the same.
What do you mean it's not given to you in written? Then what is page 29?
Page 29 is the typed copy, my lord.
No, that's what is written, isn't it? It's not an oral notice. It's not a oral grounds of arrest.
Vihan Kumar's judgment says I have to be furnished in a written form, and my relatives have also should also be furnished the same.
So is it not a written form, this one? Page 28.
It's only there in the charge sheet, my lord, but this was not furnished to me. It's only there in the charge sheet. And neither my relatives have been furnished with the same.
Your signature is also there.
Correct, my lord.
So this is not your signature or what?
This is my signature,
There.
allegedly, but the same has not been laid down as per the requirements laid down by Vihan Kumar in Prabir's case.
What is laid down in Vihan Kumar? Tell me.
It has to be, the factual circumstances has to be specifically written down, not just the charge section. If I may take you to,
No, it says you are arrested on 3:40 a.m. in the morning for possession of
correct,
possession of what?
that also not written. In violation of section 8C, only that is written. That point of controversy, my lord, has also been considered by a coordinate bench, my lord. Same circumstance.
So that plea of not being informed in writing was not taken by you in the earlier bail application.
I have, my lord.
Huh?
I have. I have, but the trial court rejected my bail application merely on the ground.
No, I'm not talking about your case. I'm talking about that case you have referred. Vanal Su Apautu.
My lord.
Bail application 44,
Yes, my lord.
wherein bail was granted by a coordinate bench of this court.
Yes, my lord.
You had no such kind of ground in that case. You did not take any ground like that about not being given in writing.
Before,
Grounds of arrest.
I have, my lord, but before submitting my grounds, the bail order was passed at the outset.
I see. Okay. So here you have the same sort of thing, and in addition, you say that the grounds of arrest has not been
Correct.
properly informed to you.
Correct.
Okay.
My lord,
But the recovery of the suspected substance was in your presence, isn't it?
correct. They,
Okay.
that, all those,
So can you say that you do not know what is that in that packet which was recovered?
that,
Can you insist that you should give me all the detail? It was red in color, green in color, or yellow in color, and that was recovered from this bag, that bag.
My
So
lord-
the entire minute detail has to be given over.
it has to be, my lord. It has to be. If I may take you to Vihan Kumar's judgment. Vihan Kumar specifically says
Paragraph
19, 20, and 26. Lordship has got it. Thus, the requirement of informing the person arrested of the grounds of arrest is not a formality but a mandatory constitutional requirement. Article 22 is included in Part 3 of the Constitution under the heading Fundamental Rights. This parad talks about Article 22 violation, my lord. And para 20. We have already referred to what is held in paras 42 and 43 of the decision in Pankaj Bansal. This court has suggested that the proper and ideal course of communicating the grounds of arrest is to provide grounds of arrest in writing. Obviously, before a police officer communicates the grounds of arrest has to be formulated. Therefore, there is no harm if the grounds of arrest are communicated in writing. And at the last sentence,
from where are you reading?
para 20, my lord. I've skipped over to para 20. We have already referred.
It says that there is no harm if the grounds of arrest are communicated in writing,
Correct.
although there is no requirement to communicate the grounds of arrest in writing. It's not mandatory. If it's in writing, well and good. If it's not
However,
in writing, there's no harm.
however, at the last sentence, therefore, the police should always scrupulously comply with the requirements of Article 22. And this Honorable Court concludes the same in para number, starting from para number 26
26 of what?
of this judgment, my lord.
The same judgment.
Vihan Kumar, yes. The requirement, if I may read, my lord. Therefore, we conclude the requirement of informing a person arrested of grounds of arrest is a mandatory requirement of Article 22(1). The information of the grounds of arrest must be provided to the arrested person in such a manner that sufficient knowledge of the basic facts constituting the grounds is imparted and communicated to the arrested person effectively in the language which he understands. The mode and method of communication must be such that the object of the constitutional safeguard is achieved. When the arrested accused alleges non-compliance with the requirements of Article 22(1), the burden will always be on the investigating officer to prove compliance with the requirements of Article 22. Non-compliance with Article 22(1) will be a violation of the fundamental rights of the accused guaranteed by the said article. Moreover, it will amount to a violation of the right to personal liberty guaranteed by Article 21 of the Constitution. Therefore, non-compliance with the requirements of Article 22 vitiates the arrest of the accused. Hence, further orders passed by a criminal court of remand are also vitiated. Needless to add that it will not vitiate the investigation, charge sheet, and trial. But at the same time, filing of charge sheet will not validate a breach of constitutional mandate under Article 22(1). Even this court, my lord, on the number of bail applications, have granted bail based on this principle, which I have stated in para 15 of my bail application.
Just a minute. Okay.
Further, my lord, if I may take you to the concurring judgment of these same judgments, my lord. Justice Koteswar Singh's judgment, para 41. In
Where?
para 41 in
In Vihan
Vihan
Kumar?
Kumar. Vihan Kumar, my lord, yes.
Yes.
Para 41, the seventh line. The said constitutional mandate, your lordship has got it? The said constitutional mandate has been incorporated in the statute under section 50 CRPC section 47 of the BNSS. It may also be noted that the aforesaid provision of requirement of communicating the grounds of arrest to be purposeful is also required to be communicated to the friends, relatives, or such other persons of the accused as may be disclosed or nominated by the arrested person for the purpose of giving such information as provided under section 50A CRPC. So it is our case that the grounds of arrest, no grounds of arrest have been furnished to us. Very similarly, my lord, a coordinate bench in the principal bench, my lord, in bail application 2282 of 2025, which I have submitted before the court today, have also considered this aspect. Herein, in this case also,
Which para?
I will read from para number 14, my lord.
Read.
It is evident from the memorandum of arrest issued to the accused petitioner that it mentions the recovery of the contraband and states that there is a prima facie case against the accused petitioner under section 8C, read with section 22C and 29 of the NDNPS Act. However, it is fact that there is no specific mention or detailed description of the alleged offense committed by the accused petitioner. It is also an admitted position that section 8C of the NDNPS Act comprises various types of offenses, but the memorandum fails to specify which particular aspect or sub-offense under section 8C is being invoked in the present case to attract the applications of section 22C and section 29 of the Act. In the case of Vihan Kumar, so and so, the Honorable Apex Court clearly held that the requirement of informing the person arrested of the grounds of arrest is not a mere formality but a mandatory constitutional requirement under Article 22. I will not read all of them, my lord. The factual circumstance in this instant case and in our case, they are almost identical. In our case also, even though there is a grounds of arrest in the charge sheet and even though there is some signature there, only the section 8C is there, not the charge section. And there is no specific mention or detailed description of the alleged offense committed by us. My lord, I will not advance all my grounds of bail for now. I'm a bit reluctant because of all the other matters to be heard today. I will shorten my the length of my application. The other grounds which I will be raising is that I have no previous case conviction.
Why are you withholding some grounds?
No, withholding in the sense
You are saving it for some other day for the second application.
no, my lord. No, but the reason why I'm saying that is there are other matters, so many other matters listed today, and I'm a bit reluctant to take so long. That is why I will be shortening the length of my bail application, my lord. The other grounds, my lord, is that I'm a first-time offender. I have no previous case conviction. I'm presently looking after my stepchild and my stepmother, who is a cancer patient. I have also annexed the copies of the
Is that your stand in your application?
Yes, my lord.
Paragraph?
From para 20, in para 20, I am saying that I am the sole bread earner. In para 17, I am stating that I have a minor child and a mother-in-law who I am looking after as of now, who is suffering from cancer.
There's no other family members in the house.
There are, but since I'm the sole bread earner, my lord, in my family,
How do you earn your livelihood?
I'm a two-wheeler taxi driver, my lord.
Two-wheeler taxi driver.
My lord. Charge sheet have also already been filed, my lord. There is no reason why I should be incarcerated in jail unless specifically necessary. All these allegations against me, they can prove it before the trial.
That's it.
For now, my lord. If your lordship allows, if required, if I may be allowed to rebut the submission of the learned.
Yes. Yes, Mary.
Please, Your Lordship, with regards to the allegation that is made with the non-compliance of furnishing of the grounds of arrest. My lord, that is the ground that is already taken before the learned trial court. Now, what the report that is here before us is that the grounds of arrest was well explained, and then copy was furnished. And to be more precise in their grounds, they could have taken the affidavit or statement from the family that they do not receive the copy or the accused himself, but nothing as such. The only record that remains here before us is that copy is served and well explained in the language known to them. So, Your Lordship, whatever this was already dealt with, and there's no new improvement.
How was it dealt with? There are
Yes, Your Lordship. It's in page number 60. Si- 61, the relevant portion. Paragraph number 5.
yes.
And that is the first reply to my learned friend's one of his ground. And with regards to the grounds taken that section 37, the rigors of 37 is not attracted in this case. Yes, it is true that is the case of intermediate quantity, sorry. However, Your Lordship, the possession and how the seized articles were retrieved, it's all written there in by the witness, the civilian witnesses, which my learned friend was pleased to annex in his application also, which runs from page 44 to 47, Your Lordship. So it is clear that his involvement is clear in the case.
44 to 47.
Yes.
What is that?
It's more or less the same. I will, with Your Lordship permission, may I read the English translation in page number 46?
Whose statement is this?
This is the civilian witness. The
Civilian
speaking witness.
Caesar witness.
Caesar witness, yeah.
Yes.
My particulars are above. On dated so and so, I was invited by Excise and Narcotics and CADS. Duty to be witness as they wanted to check a house from our residence. They brought one male and a female. We then went to Lal Trakimi's residence. From the weaving shed, which was independently situated from
No,
her
just a minute.
residence.
They wanted to check a house from our residence.
I think
What does it mean?
It's one of the residents. The
Conveying
English
conveying
translation is
in
not. Yes.
lal chakima in and check
Yes.
do avangid when a stand min kransoma.
A slight
It's
English
my lord, it's a literal translation of this, what has been written here in page number 44.
How can you check a house from your residence? By what? Through online?
No, my lord.
Then what kind of
The residence
translation
of
is
Dal
this?
Chakimi is the residence of Dal Chakimi is Ramlun Vengthar, and my residence is a different place, Veng South.
I believe that a house from our residence should be translated as a house from our locality.
No, it's clear from the vernacular.
Vernacular, yes.
Something wrong with your translation, but we understand the vernacular, fortunately. So, please continue.
Yes. From the weaving shed, which was independently situated from her residence, the persons which they brought who claimed themselves as Lalsuan Tuangi and her son, Lan Liana, took out 9 soap cases of heroin from 2 polythene and a card box kept in the uppermost shelf of the wooden almirah. The same was weighted and weighed so and so grams. The seized articles were then packed and then sealed again. Further, regarding La Chakimi, she was not arrested since it appeared that she did not know anything about the heroin, and hence the owner of the heroin, Lal Son Tuangi and her son, were arrested by the duty officer. I then appended my signature as a witness.
Tell me
And-
one thing.
Yes.
How are these 2 persons, accused persons, connected to the house owner? Why did they keep their belongings in our house?
Your Lordship,
Any
that
relation? It was the house of Lal Chakimi.
yes, it's
There has to be some explanation for that.
yes.
Otherwise, you don't keep things in some people's house like that.
Your Lordship, if I may take Your Lordship kind attention to page number 39, the English translation is in page number 40.
31?
39. 39. 39. English translation is in page 41.
Who is this?
This is the co-accused, the
Co-accused.
mother.
Mother of the present petitioner.
May I read, Your Lordship?
Page
41.
41, right.
My particulars are as above. I have no proper occupation. My main source of income is selling heroin. I have been arrested in connection with heroin and had
Even been
been
in jail.
I used to deal with persons from the east since before. I do not normally possess heroin at my own house. I used to keep it at the weaving shed of Pilal Chakimi of Ramlun Vengkar with my children if I would sell the same. So that is how they make it.
No, just a minute. Type copy. Can you read the vernacular at page
Yes.
39?
Yes.
The handwritten one.
Ka particulars tu at sungami ang hiyan ni azon na mumal ka nei lova. Heroin zor hi ka azon na puiber ni heroin wang hiyan man po ka tok to in jail po ka tang hial to ani. Tun ma atang to in ko chak lampang mi ka dor china. Heroin hi ina ka kol zen lo boka ka shal don nin Pilal Chakimi of Ramlun Vengkar puanta na ina ka fatinen kan da china ni. Tuna heroin min man sakhi pukhu man ne na changa kala kania ka fatinen hong som ve ve kan cha thenga ke chuan hong sari kala shal lo min man sak ani heroin min petu hi pukhu Min petu puku mahi address ka shilawa ama poi kalam hulawa phone chobin kanim bechina heroin kan cha poi mi shang shang aron tira ina min wan petop zel ani.
Nal Chakimi of Ramthar Vengthar Wantana Ina Kafatan in Gandachin. Why? Still, there's a question why still again. Mr. Aldrin, what is the reason? Why do you choose Lal Chakimi's house to keep your heroin?
My lord, my information is also limited to this. And what is very interesting in this case, my lord, is that Lal Chakimi, she, as I have mentioned before, she is not the accused. Normally in NDNPS cases, if contrabands are arrested like this, then she will clearly be amongst the accused. But not in our case. And she's not even part of the prosecution witnesses as well. She's absolved from this case.
Your Lordship, the exoneration of the house owner is explained by the applicant himself in page number 37. It's from their own statement that she is not indicted, in the case.
No, thing is that Lal Chakimi has got some weaving machine there. Somebody is employed there for the weaving thing.
Nothing as such is in record. Just
So
that there
what-
is a separate house, a weaving shed.
No, that's why. Why do they keep it there?
The reason for keeping
And
is
why
not.
do they select Lal Chakimi's house? Who is she? Is she related to them?
Nothing is written, Your Lordship.
Then why she's also not mentioned as a prosecution witness?
Your Lordship, with Your Lordship permission, may I read page number 36? This is a statement of the applicant.
I have read it
Okay.
already,
Because,
but it doesn't explain much.
yes, it's because he himself stated that they never informed her the articles
He,
that is kept in her house.
petitioner is an addict, actually. He's an addict, and he and his wife sell this stuff. And the mother also sells. All of them are in the business. But they choose Lal Chakimi's weaving shed to keep the stuff. So I don't know why. And where is the charge sheet? Shit.
Page 21.
Why Lal Chakimi is not mentioned in the list of witnesses? She was not present at that time. Yes, anything else, Miss Mary?
Yes, Your Lordship, in my humble opinion, my lord, there is a serious irregularity in this petition, and the petition is not maintainable in its present form and style, because this petition, when I go through the petition, it's as if the petitioner, the applicant himself, that is the accused, himself submitted the application, but then on seeing the page number 18, that is the affidavit is duly signed by his wife, who stated that swearing competent, authorized, competent to swear this affidavit, but there is no authorization as such. But the contents of the petition, it's as if it is written by submitted by the petition, the accused himself. The normal procedure that we practice is that we obtain the authorization from the accused if we are going to apply any application on their behalf. No authorization, no power of attorney or any affidavit in this regard. Just that her plain one affidavit.
Oh, she says I'm authorized and competent.
Yes, but
to
there
say
is
that.
no authorization that we should see. We can see. In other cases, the authorization, it will be countersigned by the jailer, superintendent of jail, etc. That I do hereby authorize so and so to sign on my behalf, etc. Or take any necessary actions.
What is the name of the accused person?
Lalming Liana.
And the co-accused, what's the name?
That's on Tuangi.
Huh?
That's on Tuangi.
Nalson Tuangi. Okay.
That's
My lord, if I may kindly make a very short reply.
Now, before that, Miss Mary,
yes, Your Lordship.
it's grounds of arrest. This appears, you have a copy of the grounds of arrest.
I have what is annexed here in the petition.
It's the same thing here also. It's page
Yes.
29.
Yes,
I think the photocopy is at page 28.
yes.
This is in the form of a format. How do you make out of it? You have been arrested on 3:40 a.m. of 15 August for so many options are there. One option is ticked, that is possession
Yes.
of what? Any other tick mark?
Possession of narcotic psychotropic substance, controlled substance in violation of 8C. 8C is just a prohibition of any person not to indulge in manufacture, sale, or possession, etc.
So what exactly has been possessed by the person?
The
How do we make of it?
the seized articles, the heroin, Your Lordship, 111 grams of heroin.
Is it written here anywhere?
In the grounds of arrest.
Yes. What is
100,
arrest? What has been recovered?
in the arrest memo, it's written. It's in page number 30.
Should it not be there in the grounds of arrest also? Produce, manufacture, possess, sell, purchase, transport, warehouse, use of consumer of
Your Lordship, the seizure and arrest memo was duly signed by the accused. In
Oh,
the
that's
bottom.
okay. There's no dispute about his signature.
Yes.
Well, I'm saying, what kind of grounds of arrest is this? Preparing it in a format form, then you come down to the other grounds of arrest, detention. 1, 2, 3.
Failed to produce, to refrain.
This will be common for everybody. Fail to produce proof of ID or so and so, Indian or foreigner, to refrain from influencing the witnesses so and so. If he or she is not detained, he might commit the same nature of offense. It is there like that. Then there's no tick mark or nothing like that. Then the bottom, names and address of persons arrested. There are space for 3 people. 1, 2, 3. 2 people has been arrested, and that's written by hand. So means the cops will be going around with this form everywhere, and then fill up like that and tick. And what about the next of their friends or something, relatives to be informed?
Nothing is there, my lord, that they have done so. If I may just submit this order, my lord, it will make things clear. Here, Justice Michael have reproduced the grounds of arrest memo in verbatim, where the facts and circumstances, they are specifically mentioned herein. This is how the grounds of arrest, I believe, should be written. This is bail application 13 of 2025. Although this has been withdrawn, my lord, I just want to apprise this honorable court how grounds of arrest should be written, I believe. In para 8,
Where was it withdrawn?
it's there in the order itself, my lord. The bail application herein is
You have not
withdrawn.
read it.
My lord,
Have you not read it?
I have read it, my lord. I have read
If you have read it, tell me why it was withdrawn.
It was withdrawn because this ground, it was not raised in the trial court, the grounds of arrest regarding these aspects, whether the friends and family members, they have not been furnished. I just want to impress upon this honorable court, my lord, para 8 here, Justice Michael have reproduced the grounds of arrest in verbatim, how it should be there, how it should be written.
This has been reproduced. Where is the form? From where it has been reproduced?
I'm not sure, my lord. However, my humble submission is that I believe it should be written like that.
Oh, nothing was decided.
Correct, my lord.
Only it was withdrawn because the
Yes, my
counsel
lord.
for the petitioner said that charge sheet is filed.
Yes, my
I
lord.
would like to approach the trial court.
Yes, my lord.
So it was withdrawn.
Yes, my lord. I'm only bringing that forward, my lord, to show what I believe how grounds of arrest should be written.
I don't know. This is what this Directorate of Revenue Intelligence have written.
Correct, my lord.
And what we are seeing here in your bail application is something prepared by the police,
Yes, my lord.
Mizoram police.
My lord.
They're distributing this kind of, what do you call, format. Will it suffice?
I don't think so, my lord. I don't think merely writing the section 8 is insufficient.
And the format which you've shown me now, this also, will it suffice?
That also I'm not sure, my lord.
Ah, you're not sure about anything.
At least I believe, my lord, I believe at least that should be the bare minimum.
You have pointed out what Justice Koteshwar Singh had also added in that Vihan Kumar.
Correct.
That aspect, has it been complied with in this case by the Enforcement Directorate? That question was left open
Yes, my lord.
because person was arrested here,
Yes, my
latest stays in Karimganj.
Correct.
So how do you inform them? That is not that aspect is not there.
Correct, my lord. And in our case as well, the relatives have informed me that they have not been furnished anything.
Have you made any statement to that effect?
Yes, my lord. I have.
Where? Where is it?
Regarding the grounds of arrest, I have stated in para number 10 to 15.
No. Regarding the
The relatives not been
not being
furnished.
informed.
In para 11, my lord, if I may read. That is humbly submitted that in the instant case, the documents relied upon by the investigating officer only contain such boilerplate reasons and not the concrete factual allegations which were required to be set out. Neither the accused nor his relatives were ever handed a written copy of the specific grounds, thereby frustrating the constitutional guarantee of being informed promptly and effectively about the cause of arrest. In para 12, that the legal position further clarifies that the duty of communication cannot be discharged by informing only the accused or only a relative alone and should be both.
Okay, we'll take a break for 5 minutes and come back. So I'll consider and pass necessary orders.
My lord, I'm deeply obliged.
Sorry, excuse me.
Item 8.
Show it as disposed.
Yes, may it please your lordship, I'm here for the applicant. And my lord, this IA is seeking continuation of a delay of 624 days in filing the connected criminal appeal against the judgment and order dated 7/12/2023.
All right, first time, isn't it?
Yes, first time, my lord.
Notice will go. At Ms. Rosie Manlomsangi, learned counsel for the applicant who submits that by filing this application, the applicant seeks condonation of 624 days delay in filing the connected appeal against the judgment and order dated 7/12/2023, passed by the Special Court of NDNPS, Lunglei, in criminal trial number 58 of 2021. Stop. Para. Issue notice, returnable by 3 weeks.
My lord, notice has been issued to the OP opposite parties
When?
on 21st 10/2025, my lord.
Where's the order? Where is the order of notice? This is the first day.
I'm sorry, my lord.
You're talking about which notice?
Copies served, my lord.
Copies, sir?
Yes, my lord, I'm
That's not a
sorry.
notice. Issue notice, returnable by 3 weeks. Ms. Mary L. Kiante, learned additional public prosecutor, accepts notice on behalf of all the respondents, and therefore no formal notice be served. Applicant shall, however, furnish requisite copies of the application, if not already done. List again after 3 weeks. Objections, if any, may be filed before the next returnable date.
Oblige.
Item 9.
Yes.
May please, Your Lordship. My Lord, this IA is for incorporating two documents, airship certificate number 711 of 2012 and order dated 10/9/2012, my Lord. At the time of filing of the appeal, these two documents could not be procured by us. We have only obtained these documents on 27th August after filing of the appeal. So, as I've said in my main memo of appeal and my condonation application, my Lord.
What is the stage of the appeal?
Stage of the appeal is admitted, my Lord, and TCR has been called for, my Lord.
Yes,
No objection from the
okay. All right, Mr. Lalviagno Vatampe, learned counsel for the applicant, who submits that by filing this application, the applicant seeks incorporation of the order dated 10/9/2012, passed by the Court of Civil Judge 3, Aizawl, in airship certificate application number 711 of 2012, and also the airship certificate of the same date. in the appeal filed by the applicant. Stop. The learned counsel submits that a copy of the order as the and the heirship certificate could be obtained only after filing of the connected appeal. And therefore, the instant application has been filed seeking incorporation of the same in the appeal. So, Ms. Linda Zothankiwangi, learned counsel for respondent number 1, and Ms. Mary L. Kiangte, learned government advocate, appearing for the state respondents, have no objection to the prayer. In view of above, the IA stands disposed of as allowed and as prayed for. Then in the next, in the main appeal, we write like this: in view of the order passed today in IAC number 196 of 2025, the appellant shall file an amended
Yes, my lord.
memo of appeal by incorporating the order dated 10/9/2012, passed in heirship certificate application number 711 of 2012, and the heirship certificate itself within a period of 1 week
Yes, my lord.
from today. When should we list it?
After a week, my lord.
Just again after a week.
Grateful, my lord.
Item 10.
May I please, Your Lordship? My lord, we have filed this application for staying the operation of the ex parte judgment and order dated 29/11/2022 and decree dated 29/11/2022, passing declaratory suit number 3 of 2021. My lord, in this case, the applicants herein were wrongfully evicted by the respondent's family on 18/7/2025.
This is an application for stay.
Yes, my lord.
And what about the appeal?
The,
And what about the delay condonation?
it's not, notice has been issued and I am not sure if etiquette is not written yet.
Delay has to be condoned first. How do we stay straight away like that?
Yes, my lord, even though the respondents had, family had wrongfully evicted the applicants from their house. That is why we have filed this.
Please tell me what steps have you taken in the delay application?
We have taken,
When was it issued, notice? 14/10.
yes, my lord.
How many respondents?
Sole respondent,
Sole respondent.
yes, my lord.
See, in such a case, what is done is, first of all, the delay is considered whether to be condoned or not. If it's condoned, then we take up the appeal.
Yes,
And if court finds some substance and feels that a stay is required, then the appeal is admitted, then the order is stayed. So today, your limitation, your condonation application is yet to be allowed.
yes, my lord.
So we cannot straight away go to the stay application, you see. What is the urgency in
The
moving the stay?
urgency is that, my lord, the respondent's family had forcefully evicted the appellants from their home
When?
on 18/7/2025, which is at para number 2, page number 4.
In July.
Yes, my
We
lord.
are in November now.
No, my lord. There's eviction case going on, execution case going on, and in that execution case, I was issued a notice, which is at Annexure 2, page number 17 and 18. I appeared on the execution case. Even though the execution case is going on, no notice has been issued for my eviction. The respondent family forcefully evicted me from my property
When?
on 18/7, which is
So there is no emergency. You already evicted in July, August, September, October, November. 4 months have gone now. You are living somewhere else. We'll examine the legality or otherwise of your eviction.
Yes, madam.
But first thing first, we have to see the delay condonation.
Yes, madam.
If delay is condoned, definitely we look into your stay application. We'll do one thing. We'll list the matter again on Monday or Tuesday.
Yes, madam.
And I'll ask the registry to put up a note regarding the tracking of the postal consignment.
madam.
The respondent resides in which place?
Resides at Setlun Lunglei.
Okay. Address is proper?
Luang Mual Lunglei, madam.
No. There's no Luang Mall. It says Setlun Lunglei.
Yes, madam. I'm sorry, I was saying the applicant's address. The respondent resides at Setlun Lunglei district.
Okay. Now, thing is that there's no house number or, like
Yes, madam.
postal at the pin code and all, nothing like that. It just says so-and-so, son of so-and-so, resident of this locality. That's all. Do you think it will reach like that?
My lord, that is how in the declaratory suit, that is how their address.
Supposing the notice has not reached them,
Yes, madam.
you may consider
This.
seeking permission of the court to file to serve by Dasti, if that is possible.
Yes, madam.
That you think about it. We'll post it again on Monday.
Yes, madam.
Notice sent to the sole respondent appears to have not been served. No, you cancel that again. Rewrite. Office to list the matter again on 10th of November 2025. And put up a note regarding notice, regarding service of notice upon the sole respondent by tracking the postal consignment.
DPO Bhai.
For admission, item 2.
Your Chief, we have submitted a rejoinder affidavit against the respondent number, against the affidavit in the position filed by the respondent number 1, 2, and 3 this morning.
You filed.
Yes, my lord, this morning. And my lord, if we may be given another 1 week time to submit another rejoinder affidavit against the respondent number 4.
Morning, what did you submit? Against?
Respondent 1 to 3.
1, 2, 3.
Yes, my lord.
Mr. Lomo Maralte,
Yes, my lord.
learned counsel for the petitioner, submits that a rejoinder affidavit has been filed by the petitioners against the affidavit opposition filed by the respondent numbers
1, 2, and 3.
1, 2, and 3 this morning. Stop. He also submits that he may be given a week's time to file rejoinder affidavit against the affidavit opposition filed by the respondent number 4. Miss Baby Laldin Zoli, learned counsel, appears on behalf of respondent number
1 to 4.
1 to 4. Next para, in view of above, let the matter be listed again after a week. Petitioners may file rejoinder affidavit of the rejoinder affidavit against the affidavit in opposition of respondent number 4.
Obliged, my lord.
One more line, registry shall verify and connect the rejoinder affidavit filed by the petitioners, this said to be filed by the petitioners this morning to the record.
Item 3.
Lordship, I'm on behalf of
Just a
my
minute, this you put in that bail application, no? Which I said it should be disposed, put in the file.
yes, I'm on behalf of my senior, Mr. Johnny L. Chong, counsel for the petition in this matter, my lord, who
Yes.
is on leave right now. So if the matter may be taken up after 2 weeks, my lord.
Yes,
There's no objection, my
All
lord.
right.
But however, my lord, let records be called in the meantime because
which records?
the trial court records. Because one contention, what the grounds of discharge was that there was absence of acknowledgement receipt by the officer in charge in the Goda, in the Goda against the peace contraband. So,
Records will be called only once it's admitted, not now.
oh my lord.
Mr. Johnny L. Tochong, learned counsel for the petitioner, is said to have some personal difficulty to appear before the court today. As paid for, matter stands adjourned 2 weeks, for 2 weeks.
Obliged, my lord.
Item 4.
Lordship, service report for respondent number 1 and 4 is not yet returned till date.
When was the notice sent? 1 to 4.
1 and 4.
You're talking about 1 and 4. Isn't it?
Yes.
1 and 4. Who are 1 and 4?
Sir, number 1 is the Secretary Ministry of Defense and respondent number 4 is the Deputy Commissioner, BC Siaha District.
I think you should take fresh steps.
Yes, Your Lordship.
You take fresh steps because notice was issued to them way back in the month of June. We're in November now. Please write down. Neither unserved notice nor AD card has returned back from respondent number 1 and 4. Stop under the circumstance, petitioner to take fresh steps for service of notice upon them by registered post with ADD. Within 3 working days. Yes, what about the others?
Lordship, I'm appearing on behalf of respondent number 2.
Yes, what is your submission?
Lordship, we did not receive instruction yet. May I seek time for filing a show cause reply?
Respondent number 2, Girish Prasad Singh,
Yes, my lord.
Chief Engineer,
Yes, my lord.
has paid for 2 weeks time is granted to Ms. Baby Laltin Zuali, learned counsel representing respondent number 2 to file show cause reply of respondent number 2.
Lordship, same prayer. I'm for respondent number 5 and 6.
Your good name?
Larin Thari.
Similarly, Ms. Lalrin Thari, learned counsel for respondent numbers. Respondent number
5 and 6, Lordship.
5 and 6 is also granted. You make it 3 weeks instead of 2, okay? 3 weeks time. File a show cause reply. List again after 3 weeks.
Item 5.
My lord, in this contempt petition, there are 5 respondents. Respondent number 3 notices return back with a note that the addressee left. Your Lordship, may kindly see the office note dated 30/10/25.
What about 1 and 2?
My lord, I'll represent respondent number 1. I may be filing my power today.
Only 1.
Yes, for respondent number 1 only.
Okay. Who is number 1?
Notice
Home
upon
Affairs. Number 2 is NPCC.
2, 4, and 5 is still awaited, my lord.
When was it sent? Notice?
We were directed to take steps on 22/9/25.
Please write down. Mr. Silal Fagzola, learned counsel, appears for the petitioner.
Okay, madam. Okay, madam.
Stop. Office note dated 30/10/2025 indicates that notice sent to respondent number 3 has returned back with the postal note, open inverted comma, addressee left, stop, RTS in bold, RTS, close inverted comma. Stop. As for respondent numbers 1, 2, 4, and 5, comma, AD cards are awaited. Next para. At this stage, Ms. Zaram Sangpui, learned counsel, submits that she has instructions to appear on behalf of respondent number 1, and she'll be filing her power when?
Today, my lord.
During the course of the day. Stop. She further prays for how much time?
3 weeks time.
3 weeks time to file the show cause reply of respondent number 1. What to do with respondent number 3?
My lord, one small submission, my lord. I have a new address of respondent number 3. In fact, this respondent number 3 has appeared just recently on 4/11 before this honorable court in another contempt case, Mr. Y.L. Singh. Now I have his present address. If your lordship allow me to serve fresh notice
Okay.
and to take back the petition which was earlier served to him, my lord.
Next para. Mr. Silal Fagzola, learned counsel, submits that he has secured the latest address of the respondent number 3 and may be allowed to take fresh steps upon him by registered post with AD. Full stop. He also submits that he may be permitted to take back the
Contempt petition.
the envelope containing the contempt petition with annexures for taking fresh steps. To stop, the said prayer is allowed. Stop, let steps be taken within 3 working days upon respondent number 3 by registered post with ADD. Next para. In respect of respondent numbers 2, 4, and 5, office shall track the postal consignment and put up a note by the next date. List the matter again after 3 weeks.
I'm obliged.
Obliged.
For hearing, item 11.
My lord, it's a criminal appeal, my lord. a conviction under section 120B 468 IPC read with 13(1)D 13(2) official, my lord.
Is it a short matter?
No, my lord, it's a lengthy matter, my lord.
It'll take
Involving
some time,
30,
isn't it?
40 witnesses, my lord.
It'll take some time.
My lord,
So perhaps let the regular bench handle this matter.
my lord.
Because tomorrow again, perhaps I have to rise early.
Madam.
So when do you want it?
After a week, my lord.
After a week.
My lord.
Okay, as paid for by the parties, list the matter for hearing after a week. Okay, I think that's it. You send me the file, huh? That bail application. It was item number 7. Okay.